Hey everybody, we've just got a short letter from Chip Babcock, who represents Jed Wallace. This is in relation to the New York litigation, not the Texas one. And they are requesting an extension to the deadline to designate rebuttal experts. So here we go. Dear Judge Lyman, defendants Jed Wallace and Street Relations, collectively the Wallace defendants, for good cause, as shown below, request that their deadline to designate rebuttal experts be extended until 30 days after the court rules on their fully briefed pending motions to dismiss. The court previously dismissed the Wallace defendants for want of personal jurisdiction in a thorough 38-page opinion, but gave plaintiff leave to amend, which she did, provoking the renewed motions referenced above. The motions were fully briefed as of September 3rd, 2025, and Wallace will be deposed in Texas on October 9th, 2025, either as a party, if the motions are denied or still undecided, or at plaintiff's request as a non-party pursuant to a subpoena, which Wallace has accepted if the motions are granted. Under the current schedule, the Wallace defendants must locate, vet, agree to pay, and disclose rebuttal experts by October 24th, 2025, a process that imposes significant unnecessary expense and burden if the motions are granted. Saving that expense constitutes good cause for this modest extension. The party's next scheduled appearance before the court is on October 3rd, 2025 at 2 p.m. Eastern, which is obviously today. We ask that the court take up this matter at this time if feasible. So they're asking judge, because the hearing was not scheduled for this, but they're saying to the judge, look, can we just allocate a bit of time to deal with this issue, which is not unreasonable. Whether Lyman does or not is another matter we will soon find out. Plaintiff opposes the Wallace defendants' request, contending that a proposal to permit experts to provide supplemental reports by October 17th to incorporate deposition testimony taken after September 30th is sufficient to address any issues related to expert discovery. Plaintiff's purported proposal is irrelevant to the Wallace defendants' request and does not address or remedy the good cause basis justifying the requested extension. To evaluate good cause for a stay pending resolution of a motion, the court considers 1. The breadth of discovery sought, 2. Any prejudice that would result, and 3. The strength of the motion. Courts consider the strength of the motion and whether it is potentially dispositive. Here, the motions present substantial arguments for dismissal of all claims on jurisdiction, which the court has previously granted, venue, and merits. The Wallace defendants previously requested a stay of all discovery deadlines pending the resolution of their original and eventually granted motions to dismiss. In its prior order denying the Wallace defendants a stay of discovery deadlines, the court concluded that the pendency of a related action in the Western District of Texas meant that the Wallace defendants' burden to engage in fact discovery would not be significantly impacted by the court's decision on the motion to dismiss. But that calculus flips for expert discovery. While relevant facts may be similar across multiple claims, defenses, or even lawsuits, expert interpretation and relevance depends on the specifics of the claims and defenses asserted. Here, the Wallace defendants not only filed a motion to dismiss or transfer based on deficient jurisdiction and venue, but also for failure to state a claim. Each of Lively's claims should be dismissed on this separate basis, but if any of Lively's claims are dismissed, their dismissal will impact the breadth and scope and time and expense of expert discovery. Some experts may not be needed at all, depending on what claims and defences remain, if any. The same would be true if the court were to transfer plaintiff's claims to Texas, where the Rule 12b6 motion would remain to be resolved. Temporarily staying expert discovery now, specifically the Wallace defendant's deadline to designate rebuttal experts, may eliminate a significant portion, if not all, of this burden and expense. Finally, any prejudice to plaintiff from staying the Wallace defendant's deadline to designate rebuttal experts pending resolution of the motion would be insubstantial. The court's previous ruling denying the Wallace defendant's request to delay discovery as to them focused on prejudice if Lively were not permitted to obtain potentially relevant factual information from Wallace as a witness regardless of his status as a party. That factual discovery is ongoing, and this request is not intended to affect plaintiff's deposition of Wallace, scheduled for October 9th, 2025, for which the undersigned counsel has already accepted service of a Rule 45 subpoena. Again, expert discovery is different. In Richards, the court found that granting a stay of expert discovery would not prejudice the plaintiff, even though plaintiff argues that she would be prejudiced by a stay because her reputation continues to be harmed. The mere passage of time is not sufficient prejudice to defeat a motion to stay. Nor would a stay limit Lively's ability to work with her experts and prepare their reports, should she wish to do so while the motion is pending. And a limited stay of expert discovery is unlikely to significantly delay resolution of the case. Here, briefing on the motions is complete. Should any claims survive the motions, and they should not, the accelerated expert discovery schedule relating to the Wallace defendants should resume quickly. In sum, each good cause factor weighs in the Wallace defendants' favour on this request for a limited stay of expert discovery. The Wallace defendants therefore ask that the court grant this motion and relieve the Wallace defendants of their expert discovery deadlines until 30 days after the court, in the unlikely event, denies the Wallace defendants fully briefed pending motions. We appreciate the court's attention to these matters. Now, it's a reasonable argument. What will Judge Lyman do? I don't know. I would like to see Judge Lyman at least agree to have a conversation during the hearing. He's not obligated to, and he may not have allocated enough time to do so, but we will see. Thank you for joining, and I will see you with the next one.